Okay. Welcome. Welcome, welcome. It's a pleasure to have you all in class. This is a packed class. This room's pretty full. Usually we're in the other room for big class, but we'll have fun here. Any questions before we get started? Okay. Yeah. First issue is attendance. You'll need the iClicker app. I think you'll know to download it. It's from Reef. If you don't know where it is, there's a link on the syllabus. Please be on time. 12:20 is 12:20, not 12:21, not 12:22. I will start on time, and if you're late, I will say something about it. So please be here before class starts. That way you're not late. Second thing, I will ask all of you to please fill out one of these name cards. Please bring these for all of your classes. Just take one out, fold in half, and write your name in nice big letters. I'll give you a couple markers. And please pass these around. Bring these to class every day, please. The last freebie is a tradition of mine. I started teaching 8 years ago at South Texas, and it was my birthday, my first day of class. And I brought cookies for everyone. And then the next year I forgot. It's like, where are our cookies? So I have cookies for everyone. Please pass these around. I don't want to bring any home, so bring them to the lounge or wherever else. Okay. There you go. One more. Okay. Okay. That's all the free stuff you get. That's it. You're done for the semester. You've maxed out. Yeah, you actually took two, so you rip it in half. Yeah, just take one. Yeah, and just give it to your neighbor. Yeah, and they fold in half, just like this. Write your name, your nickname, whatever you want me to call you. I'll call you. I don't care what you write here, but whatever you write here, I will call you that. And big letters with marker, not with pen, so I can actually read it. My vision has gotten worse. I didn't need glasses 8 years ago. Now I have glasses. Okay. All right. Well, you're passing those out. Let's get started. I assume you've all seen the syllabus. Yes? The answer should be yes. You're now in your third semester of law school. You should have seen this. You'll have the book. Is a book in stock? Yes? Okay, very good. So let's start off. I want to walk through the syllabus and give you an overview of the semester. By now, you finished Property 1. Property 1 and Property 2 have very little in common. It's one of the biggest surprises for Property 2 students. Like, wow, what about all the stuff we learned last year? There's not much continuity. The things you hated, like future interests, don't really play an interest in this class. No pun intended. They don't really play a role in this class. Property 1 is generally how do you acquire property in the abstract, right? Property 2 is a much more, shall I use the word, practical class. It involves land transactions, mortgages, sales, restrictions in the use of property, government regulations of property. All the things that you probably thought property was, that's what this class is about. It's not about sort of, fox hunting and things of that nature. Right? This is a little bit more realistic. As a result, you'll find the cases in this class are more modern, more 20th century, 19th century cases. Let's say 18th. Anyone else need this? Yeah, can you bring it over there with the markers, please? Thank you so much. Yeah, don't use your pen. Please use the markers. I cannot read the pen. Yeah. If you use the pen, just go over and marker. No, I have plenty of markers passed around. Just use those. I cannot read pen. It's too small. All right. Okay. So let's walk through the syllabus, and that will be the beginning. Class starts at 12:20. Please be here on time. I'm very careful at time. I will start on time. I will finish on time. You have to be here on time. We will have a 3-hour exam, like always. It is completely open book. You can bring whatever you want. It will not help you. That's usually the rub of open book exams. If it's open book, your notes will not help you at all. So it doesn't matter. I post all of my old exams, as well as the A+ answer, and in recent years, a memo explaining the exam. I encourage you all of you to take as many of these exams as possible. I don't just mean look at them. I mean actually take 90 minutes, take an hour, and take it under time. I have old midterms up there. You should probably take those also. Okay? I take attendance using the app. If you don't have the app, you can download it. If you don't have a phone, you can use it on your laptop. If you don't have a phone or a laptop, you can talk to me. I haven't had one of those people yet, but they might exist. But we will make an accommodation. But please be sure to write your name with marker and to always check in with class. OK. My office hours are right after this class. Do you have class after this one? Yes. Of course you do. Do you have class before this? Yes. OK. Well, what times do you not have class on Tuesday and Thursdays? 5:30. 3:30. OK. All right, then come by at 3:30. Just email me. But I'll stick around if you need me. OK. It's always tricky with office hours. They never quite line up just right. All the classes are recorded. That little thing right there, that's a camera. They're actually streamed live to YouTube. I have all of my past year's lectures on YouTube. That's an advantage for you. I encourage you, in the strongest terms, to watch the previous year's lecture before class. Every year, the best students will watch last year's lecture. They will sit in class, and they will watch the current lecture again. Now, I don't encourage you to do all three, but at least try to prepare yourself. Thank you so much. But prepare yourself. Anyone else need a marker? Yeah, oh, I know, the cap's missing. Just run these to the back, please. Yeah, just both of them. Thank you so much. Yeah. I encourage you to at least watch the videos. YouTube has a feature. You can watch things at double speed. You can use it, right? I talk fast, but you can move even faster. So a 90-minute lecture is 45 minutes. You can watch on the Metro. You can watch it at the gym. Take advantage of these videos. It's impossible for you to sit here in class and absorb everything. In fact, I encourage you not to write down everything I say because you're not paying attention. Sit here, absorb it, embrace it, welcome it, love it, and then you can actually go back after class and fill in gaps. I have a microphone here. It picks up everything I say. It generally will not pick up what you say. It's just the technology doesn't permit it. So it's hard to hear the answers, but at least my questions are here. I generally try to repeat a student's answer to make sure everyone hears it. You tend to talk very low. But the videos will be helpful for you. I encourage you to use them. There's a link here on the syllabus for a Google Drive folder. If you click on that, there are a bunch of files there. Most of them are empty. They start off empty, and as the year progresses, I fill them with stuff. So for example, if you click class number 1, OK, here is some of the notes for today. OK, and I'll add some other stuff I want to talk about. So just make sure you use that link. Where else? Oh, syllabus. Who are you? OK. The schedule is a schedule. I have never once fallen behind in 8 years. I will not fall behind. Whatever assignment I give you in a given day, that's it. No read 10 pages ahead. It's what I give you is what I give you. We start, we finish on time. I respect your time, so respect mine as well. The schedule's done. We start off with what's called adverse possession, which is sort of a weird thing that people say, wow, that's like stealing, Josh. Kind of. But it's a way of acquiring property from the prior owner without perhaps paying for it. We move on to what we often call the sales contract, how to actually sell real estate, how to sell property in the United States. Just note, a couple classes are canceled. I flagged those on the syllabus. I'll move on to what are called deeds and warranty. These are the actual mechanics of how you purchase property. OK, moving on. Next, we move on to what's called recording, right? That after you buy a piece of property, how do you provide notice to people that you purchased it, which is an important topic. Then we move on to a topic you probably did in torts, which is nuisance. We just do it from a slightly different angle. Then we move on to what's called land use controls, right? If I have a neighbor who's polluting or have a neighbor who's making noise, how do I control how someone else uses their land? You can do that through what are called easements. We will get there. After we finish easements and covenants, move on to land use regulation by the government. How does the government regulate the use of land? They can do so through use of what's called zoning, as well as eminent domain, or when the government takes your property and pays you for it, hopefully. Okay? Okay, that is the semester. We'll have a final exam review on the 21st, so towards the end. I will go over one of my old exams. If you want to take one of my old exams, I will be happy to grade it for you. I'll do it for you, I promise, and I'll go over it with you. But you need to actually take the initiative to do it. Most people won't take me up on it. They'll never do it. But I give you that offer, and you're welcome to try it. OK. Questions before we get started? And please, always raise your hand. I will take questions at any juncture. All right. The way that I do recitations is a little bit different. I go up and down the rows. So I'll maybe just start there, or I'll start there, and I'll just go up and down each row. So everyone gets one question. There are about 65 of you here. I think 65, 70 if I had to guess. I can do about 40 to 50 people a class with questions. So you're basically on call every day. You just don't know which way the line's going to go. So you're always on call. You get one question, maybe two if it's a follow-up. But you're basically always on call. Please be prepared. You also have to pay attention to what I ask the person sitting next to you. Because if I ask him one question, she'll need to know what I just asked to follow up. You can't just sort of zone out. So please, it's a little bit energetic, but I think it works well. OK. Anything else? All right. Let's start with a movie. I know people love to watch movies. It's a news clip from Flower Mound, Texas, which is sort of near Dallas. Anyone from there? From Flower Mound?
From a neighborhood.
OK, so it's outside of Dallas. And this is a clip that's about 7 or 8 years old, but I think it explains the topic of adverse possession quite well. So I'm just going to play this clip, 2 minutes long, and then I'll ask some questions.
Flower Mound's Waterford Drive is lined with well-manicured $300,000 homes. So when a new neighbor moved in without the usual sale, mortgage-paying homeowners had a few questions.
Sorry.
What paperwork is it and how?
Okay, let me start it again with the audio playing. So.
Flower Mound's Waterford Drive is lined with well-manicured $300,000 homes. So when a new neighbor moved in without the usual sale, mortgage-paying homeowners had a few questions.
What paperwork is it and how is it legally binding if he doesn't legally own the house? He just squats there.
Lee Lowry and her husband told me the house down the street was in foreclosure for more than a year. The owner walked away, then the mortgage company went out of business. Apparently, that opened the door for someone to take advantage of the situation. Kenneth Robinson told us he's no squatter. He says he moved in on June 17th after months of research about a Texas law called adverse possession.
This is not a normal process, but it's not a process that's not known. It's just not known to everybody.
Robinson says this piece of paper gives him rights to the house. It's an online form.
Just flag it. He says affidavit of adverse possession. OK, we'll come back to this later.
And filed at the Denton County Courthouse for $16. It says the house was abandoned and he's claiming ownership.
I went through, looked at and added some things here, you know what I mean, for my own protection.
The house is virtually empty, just a few pieces of furniture, no running water or electricity. But Robinson says just by setting up camp in the living room, Texas law gives him exclusive negotiating rights with the original owner. If the owner wants him out, he would have to pay off his massive mortgage debt, and the bank would have to file a complicated lawsuit. Robinson believes neither is likely. So if he stays in the house, after 3 years, he can ask the court for the title. That's your goal eventually, is to have title of this home, to be the owner of this house.
Absolutely.
And
I'm on record, you know what I mean, at this point, since I possess it, I am the owner.
Robinson posted no trespassing signs after neighbors asked police to arrest him for breaking in. But Flower Mound officers say they can't remove him from the property because home ownership is a civil matter, not criminal. Lowry and her neighbors continue to look for legal ways to get him out.
Or if he wants the house, buy the house like everyone else had to. Get the money, buy the house.
Robinson says he's not buying anything. As far as he's concerned, the $330,000 home is already his, and he has the paperwork to prove it. Casey Norton, Channel 8 News.
All right. There's Zeke, you're up. What was Mr. Robinson trying to do there?
He was trying to gain title of the house by adversely possessing it.
Okay, so generally, if you want to adversely possess a house, what do you have to do?
There's 4 elements.
We'll get to the 4 elements later, but just as a general matter, what do you have to do?
Knowingly take ownership of
Okay.
something, premises. That,
Now, who owned the house he was squatting in?
I guess right now, no one.
Okay, right. So Jacqueline, why was Mr. Robinson in some of a unique position, right? This guy, he actually was pretty smart. He taught a class at SMU Law School in how to adversely possess property. He actually he made like a little business out of this. Like he would sell books and stuff. He made a little thing out of it, right? But why was Mr. Robinson kind of smart to pick this property of all properties to go after?
It was in foreclosure and it was abandoned by.
So no one cared. Okay, so this video is about 7 or 8 years old, and at the time in America, a lot of properties were basically abandoned. Right, people had mortgages, they couldn't afford to pay the mortgages, so instead they just sort of walked away. A lot of the financial institutions that wrote the mortgages went out of business, so the homeowner disappeared, the bank shut down, so basically no one cares. So you have this house. See what my YouTube videos I'm watching are, right? You have this house, this empty house, sitting on the block that no one's there. So Robinson was actually pretty savvy on this one, right? He picked out a house where no one was going to care. And he did something else that was smart. What else did he do that was smart, Ernest?
He it seemed like he got an affidavit because he made it notorious.
He got some paperwork, right? He papered it. He filed with the county this declaration. That's a declaration of adverse possession. I don't know where he got this form, but he found it somewhere. And he put the public on notice that he intended to acquire this property through adverse possession. Now, I think his mistake was that he went on the news. Shortly after this went on the news, the bank came around and figured out who he was and got him kicked out. So it didn't end well for Mr. Robinson, but he actually did some things that were right. Okay, so now Stephen, let me ask you a question. How is this possibly fair? Right, one of my least favorite words in the English language, fair, right? Think of the neighbor, right? The neighbor says, if he wants his house, buy it like everyone else. How is adverse possession even conceivable in our law? Like, why should the law, right? Why should the law even recognize that this guy can even do this?
Well, I think that it's a public policy matter.
Okay, tell me why.
Because it's in the public's best interest to have property owned by somebody that's going to be a responsible party. So you have 2 possible responsible parties: the person who was defaulted on his mortgage and the mortgage company that no longer is in business.
Robinson taking care of this property?
He said he was going to live there for 3 years and maintain it.
Okay, so he was sitting there. Was he actually improving upon it?
I don't know.
Bobby, do you think he was paying property taxes?
I don't think so.
Okay, he was. He didn't get that far. He got kicked out pretty quick, but it's not enough to just maintain the property and sit there and keep it clean. Although he had no power and no heat. I don't know what he was going to do in the summer, with air. I don't know how he was going to live there for 3 years. It's pretty rough living. No heat in the winter, no air, no running water, right? Utilities, didn't pay taxes. But in theory, at least, adverse possession has a policy justification, which I think Stephen mentioned. It prevents property from just going abandoned, right? Think back in medieval times when all property begins. If you had a farm that wasn't being utilized, it's good that someone actually uses the farm and tills the soil and does stuff to the land. Is that Cece? Cece, what's another reason why we actually allow Mr. Robinson to do what he did? Like, why do we even have adverse possession? Why is that like a thing that our law recognizes? What benefit does adverse possession create?
Well, if you take over land that's being abandoned, then you can beautify it. Or
Yeah, you can improve upon it. That's Stephen's point. But what's another justification why we have adverse possession? Do you have to wait before you get adverse possession? Just as a general number.
3 years.
Yeah, 5 years, 10 years, 15 years, right? And Cece, what do we say if a person knows that Mr. Robinson's squatting their land for a decade and does nothing about it? What does that tell us about how the person views the situation?
It must not be that big of a deal if you've been there for that long.
Okay, very good. Right? If a person's not willing to actually enforce his own rights, why should the courts do it for him? Right? If the bank doesn't care enough about the property, let's sit there empty for 5 years, doesn't kick out Mr. Robinson, why should the government step in to do something about it? But is that Danny? Let me ask you another question, Danny. Do you have a house, or you ever live in a house?
Yeah.
Okay. How long did you live in a house for?
My family's home. Like,
For many years?
Yeah.
Okay. Let's say you've been living in a house, I'll just say 15 years. I'll make up a number, right? And let's say after 15 years, someone shows up and says, aha, you purchased that house from a crook. That crook was not the real owner. I am the owner. Get out. It's my house. How would you and your family react to that sort of allegation? And let's assume it's true, right? Let's just assume that's an accurate allegation that your parents were swindled, they were cheated, they bought a house from a crook who didn't own the house, and the real owner shows up 15 years later and says, ha, okay, you guys, move out, my house, get lost. What's your reaction to that?
you want to fight that.
But on what grounds? Why? It's not yours. You were cheated. Go sue the thief, but it's not your house. Got to move.
Based on our own time within the property and.
Why should that matter, though? Why should it matter that your family was there for 15 years? Who cares? It's not yours. Get out.
Well, I guess it would cause like an influx of just legal disputes in general.
Oh.
Based on these kind of.
Yeah, why might there be a legal dispute about a transaction that happened 15 years ago? Why is it problematic to try and figure out what happened a decade ago? Why is that problematic?
Could it have like the effect of looking further and further back?
Yeah.
Like,
Yeah, look, memories fade, evidence disappears, right? Maybe if your family bought it from a crook, maybe that guy bought it from a crook. Adverse possession settles stuff, right? It brings finality, closure, if you want to use that word, right? It settles the state of property after a certain number of years. It doesn't let things linger indefinitely. It creates what we might call security, right? I know that if I've been there for 15 years, no one's coming along to take it from me. And what about this guy who waited 15 years to complain? Sucks for him, right? He should have done it earlier. So at first blush, adverse possession seems like theft. Like, oh my God, Mr. Robinson's stealing this house. But there are some justifications for why, as a policy reason, we have this doctrine, right? It's not insane. Okay. So any questions so far? Okay, now you notice in the video, Mr. Robinson made a big deal about this affidavit of adverse possession, or declaration, whatever he called it. Is that Emily?
Yes.
Why did Mr. Robinson make such a big deal about this declaration, this little piece of paper, which, I mean, look, he just printed it off the internet and filled some stuff out, right? It's not like an actual thing, but he made a really big deal about this piece of paper. Why?
Well, he was making his known statement. Like, and some people who don't have legal knowledge might assume.
Okay, so for sure, it puts other people on notice, right? But let's take the case of, was it Daniel? Danny a minute ago, right? His parents were given not a made-up affidavit, a declaration, whatever. They were given an actual deed to the house, right, 20 years ago. And let's just say, again, the deed was fraudulently crafted. It was a forgery. Why should it matter that Danny's parents have this piece of paper in their hands versus just some guy's like, yeah, it's mine, whatever? Why should it matter that they have this sort of document?
Because they relied on it.
Yeah. You guys remember the statute of frauds, right? I don't want to bring you back too painfully, but it's an important thing. Having a writing is significant because it's some tangible proof that you have an interest in this land, right? It's something tangible that you can show to people. Now, Mr. Robinson basically made it up by himself, right? He just printed this document off the internet, right? But Danny's parents, for example, were given a fraudulent deed, and they can use that. And the law recognizes different standards for adverse possession based on your situation. Now, I'm going to give the Texas definitions. I think it's probably most relevant for what you'll want to learn. Even though you're taking the uniform bar exam, I think you'll still all be practicing here, 90% of you at least, so you should know this stuff. In Texas, which is what Mr. Robinson was talking about, there's a 3-year limitation for adverse possession when you have what's called color of title. Oh, that gets cut off, doesn't it?
Yeah.
Oh, you vey. Oh, I know how to fix this. Okay. Sorry. It worked in my other class. Let's try that. Worse? Worse. Okay. I will figure this out after class, so if you can just look over here and I'll figure that out later. I'm sorry. I'll fetch that later. Okay. With Texas, you have a 3-year limitation period for adverse possession. That's what Robinson said, 3 years, right? If you have color of title. Kaylee, what is color of title?
So you have written documents, or so you're like claiming that you have possession based off of.
Okay, good. Make sure you put in your notes the phrase color of title. Color of title is different than claim of right. I'm sorry, claim of title, right? So you have two phrases that are very similar, right? Let me just type this up here. You have color of title and claim of right. Color of title and claim of right. Those are different things. I promise you on the exam, at least 5 of you will confuse the two. I can assure you. No matter how many times I repeat this, you will. Okay, so Kaylee, tell us again, what is color of title?
Color of title is saying that you have possession based off of the document.
Yeah, think of Mr. Robinson, right? He had that declaration in his hand, right? When you have some sort of paperwork, the law rewards you and gives you a shorter limitation period, only 3 years. Right? The law rewards you, you have a limitation period, only 3 years. Okay? Claim of right is the 4th element of the adverse possession test. We'll get there in a few minutes. I don't want to do it now, but we'll get there in a few minutes, right? There are 4 elements, it's a 4th element. But make sure you just keep your notes separate. Claim of right, color of title. Okay? Okay, so thank you, Kaylee, for that. So in Texas, if you have color of title, the limit's 3 years. Okay? Right? There's a 5-year limit if certain conditions are met in Texas. If you cultivate or use the property, if you pay the taxes, and you have a registered deed. Right? So you don't have a color of title. You don't have basically a sort of a document showing that you own it. By the way, I'm not sure if Robinson was right about his 3-year limit. I don't think he was, but I'll just assume he is for now. But if you have what you call a registered deed, put people on notice, you have a 5-year limit. I think Robinson was probably wrong, but I don't want to say, I'm not sure. And then let's say you have nothing, right? You have no title instrument. You got 10 years, right? So the law rewards with a shorter limitation period people who have a stronger claim to the land. If you have some sort of document showing you own it, you get 3 years, right? If you pay taxes on it and you cultivate it and you improve it, you get 5 years. And if you're doing nothing on it, you get 10 years, right? And most states have a similar regime where depending on how strongly connected you are to the land, you get different amount of time. Okay, everyone with me? Everyone with me? Okay? All right, very good. And I will fix it after class. I'll call IT. I'm sorry if that's not working right now, so hopefully you can at least see this one. This is like the worst classroom in the building in terms of angles and viewing angles. It just was designed very poorly. Like that column right there, it makes no sense. It's a bad viewing angle room. They installed these a couple years ago to make it a little bit better. But anyway. Okay, I should probably put the projector here. I think it'll be a little better. Anyway, whatever. Okay, any questions on that so far? All right, so we have the general policy reasons why we have adverse possession. Creates finality, it creates certainty, it rewards people who use the value at the highest level, it sort of punishes people who don't enforce their rights, and it also has a certain societal improvement element where people can actually improve how land's being used, not just saying they're empty. So it's not insane, it's sort of crazy at first blush, but I think it serves a value. Okay. All right, so let's actually get to, oops, sorry about that. Okay, I'll call back later. Always happens, whenever I ignore a call, it goes right to my voicemail. Okay. All right, so let's actually walk through the 4 elements of adverse possession. Let's do 1 at a time. Is that Sharissa?
Yes.
Okay, Sharissa, what's the first element, please, of adverse possession? Okay, let's stop there. What does that mean, Sharissa, entry?
So that there's like it's actual and exclusive, so it's not just like
Well, how do you enter? I mean, I know it sounds silly, but just walking through it, right? How does one enter for purpose of adverse possession? What do you have to do?
so physically present.
Physically present. I like that phrase, right? You basically have to walk onto the property without permission. Think of Mr. Robinson going in there, right? Putting a little no trespassing sign on the door, right? Actually entering is a significant act, right? Shannon, why is the act of entry so important?
Because you have to be there to actually have possessions.
What does the entry do significantly?
It puts you there.
And what else does it do? There's an important effect of entering. Think of the 10-year clock, right? Why is entry so important?
The clock starts as soon as
Bingo.
you enter.
The tick, 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 right? The clock starts ticking when you have entry, right? Indeed, in adverse possession cases, often a question that's litigated is when did you enter, right? Because depending when you entered, that's when the clock starts ticking. And if you don't enter till less than 3 years, sorry, too bad. Right? So entry triggers, right? But think about it. What's another word for entry? It's trespass. You're trespassing. Now, Mr. Robinson said, this is civil, not criminal. Not exactly, right? If you just, pick any of you, right? You all have houses, you have apartments, right? Someone walks into your house and says, hey, I want to start squatting here, so I'm going to sit down on the couch. What are you going to do? You're not going to go file civil action to eject him. You're going to call the cops and say this guy's trespassing. And practically, that's what's going to happen. It might be a little different circumstance like in Flower Mound where you have this foreclosed house and no one was living there. So he was actually able to enter, right? But imagine, right, that you show up and this guy's there, you call the cops. So that's why entry is important. It's when the trespass begins. And it's risky, right? By entering the property, you're engaging in a trespass, which can be a criminal offense you can go to jail for. It's risky, right? Adverse possession is not simple. There's a risk that attaches. Everyone with me? All right, let's go there. Maria, please. Maria, what's the second element we have in adverse possession?
It must be open and notorious.
Thank you, ma'am. Yes. Open and notorious. Okay, tell me, what on earth does that mean? Open and notorious.
So open meaning that it must reasonably make other owners have knowledge that this actually.
What does the word notorious mean, Maria? I'll give you a hint. What are the first 3 letters of notorious?
No.
Notice, yeah. Notice, notorious, they're the same thing, right? You have to take an action that puts on notice the owner, the record owner, that you're squatting, right? If you quietly tiptoe onto the farm at night and then don't tell anyone, guess what? No one's going to know. Now, Mr. Robinson sure as hell is open and notorious. He won the news, right? He which is probably his downfall. But he made it public to the neighborhood, to the community, that he was squatting. Okay? You need to actually put the record owner on notice that you intend to squat. The failure to do so openly means you didn't get it. Everyone with me? Okay, is that Jacqueline? Yeah.
Because it says open and notorious, that doesn't necessarily mean that we have to specifically make sure that the owner has notice, right?
It doesn't have to. Okay, so here's the question was, does the owner have to actually have notice? You don't have to prove that the owner gets notice. What you need to prove is that you use the land in a way that he reasonably could have had notice, right? Maybe the owner is an idiot and just doesn't pay attention, right? Or just like ignorant. But if the facts are such that a reasonable person would know, you're good. Right? You can have an owner who's just an absolute, I don't want to say idiot, that's mean. Just, he's not paying attention to his land, he doesn't care. Okay, his bad, right? He didn't manage this properly, effectively. Everyone with me? Okay. All right. Is that Jessica? Jessica, what's the third element we have here? Okay, very good. And I just showed you a minute ago the Texas ones, right? 3 years, 5 years, 10 years. It's not a single period of limitation, right? The limitation period varies depending on the facts. So please, for an exam or otherwise, keep in mind the answer is not always 10 years. It's not always 5 years, not always 3 years. It might vary depending on the facts. You have to keep in mind what the situation is. Okay, now, Andrew, let's say the limitation period is 10 years. Does that mean Mr. Robinson has to stay in the house for 10 years, can't leave to go shopping, can't leave to go, to church, can't leave to go to work, he has to sit there for 10 years straight?
No.
Okay. How do we actually apply this continuity requirement?
It's, if they are using the property in the manner that the property would typically be used. So if you are there and say it's just a house, so you go on vacation, a normal owner would go on vacation, so that wouldn't disrupt the time with the property.
Okay, very good. We have to use common sense with this requirement, right? There's no obligation to sit in the house 24/7, 365 nonstop. That's insane. You have to use a house in the same manner in which a reasonable person would use it. So if it's a house, okay, you come in the morning, leave, you go to work, you come home, you sleep. However a reasonable person would use it, that's more or less how it works. Let's say you're adversely possessing a summer home, right? Let's say it's a summer home. Okay, you go there for the summer. Let's say you're adversely possessing a ski lodge. Okay, you go there for the winter, right? You have to use it in the manner in which it should be used, right? Let's say there's a ground that's used for hunting, and you can only hunt a certain month of the year. If you use it for that month of the year, you acquire it. Let's say there's a lake, right? And in the summer, it's easy to swim on, and in the winter, it's frozen over. You can't really swim on it, right? If you swim every summer on it, you've now acquired the right to swim there. So you have to actually look at how the property is being used to determine if you meet the continuity requirement. Okay. Questions on the third element of adverse possession? All right. Is it Andrea? All right, Andrea, what's the fourth? I once had a student complain about my typos, so I will do my best. What's the fourth element there, Andrea?
Entry must be adverse and under.
Okie doke. This is by far the hardest. The hardest of the four elements, right? 1, 2, and 3 you can walk through with your eyes closed, right? That's easy. But the fourth one is the one that always gives students the most difficulty, with good reason. The reason why this fourth element gives students difficulty is these terms don't have a single fixed meaning, right? Adverse and under claim of right can mean different things in different jurisdictions, right? In some places, it refers to your state of mind, right? Maybe you don't really care whether it's yours or not. You sort of just show up and says, aha, it's mine. It's not. I don't know. I don't really care. I'm gonna squat here, right? In some jurisdictions, that's enough. In other jurisdictions, you might think, oh, that's my house, right? Think of Danny's parents, right? Yeah, I bought the house 20 years ago. It's mine. No big deal. Turns out it's not. That's enough. In some jurisdictions, you gotta be like Mr. Robinson, say, screw it, it's mine, I'm getting it, right? I'm gonna squat here for 3 years, it's gonna be mine, right? The so-called hostile aggressive trespasser standard, right? Depending what jurisdiction you're in, you're gonna find a different rule for this fourth element. And we'll talk about these in our 2 cases today. I don't wanna go too far into it now, but just know that the adversity, and I'm gonna claim of right, varies from state to state, and what sort of standard you have. And we'll do the Texas one a little bit later. Okay, everyone with me? Any questions so far? Okay, is that Laura? Yeah, and if any of you wrote your thing with pen, just take a marker and go over it, because it's hard for me to see the little pen letters, but I'll do my best. All right, Laura, you want to give me the facts, please, in our first case of the semester. I feel so proud, right? Van Valkenburgh. Oh, I love the name of this case. I always think of the Valkyrie, right? Van Valkenburgh versus Lutz. Oh, thank you. You can do it later. That's fine. Laura, you want to give me the facts on Van Valkenburgh, please?
So the defendant bought lots and then decided to use the empty, unused lot next to the property.
Well, let's just be precise. Okay, so we have the lot numbers actually do matter here. Okay, so the Lutzes bought 2 lots. Which one did the Lutzes buy?
14 and 15.
Go. Everyone can see this picture. 2 quickies. Okay, so the Lutzes in 1920 bought, Lutzes bought the lots in 1912. And then about 8 years later, they bought a house in 1920. Okay. Laura, why did this controversy arise? They bought their house, they built their lot. You know, what's the big deal? What was the controversy? What happened? What gave rise to the controversy?
Like there's a lot next to theirs, number 19.
Okay, very good. So you have, it's actually 19 through 22, but just go 19 is fine. Okay. What happened there?
They were using it as a walkway
Okay. Where were they going?
to their own place.
Okay, so here's the deal, right? You have a street over here, and then you have a house over here. This was a very hilly area, right? It was hard to walk. So rather than walking all the way around here, they just cut across the lot. Everyone understand? We've all done this, right? I think most of us have. Maybe, I don't know. Maybe we're more honest. But if there's a shortcut you can take, you say, all right, screw it. I'm going to cut across this guy's lot, and I'll get to my house quicker. Okay. But they didn't just cut across and walk across the lot, right? I can't see your name tag. Is it Hanna?
Yeah.
Hannah, what else did the Lutzes do on this other plot, this little triangle over here? What else did they do?
So they had some sort of garden which they sold produce to their neighbors, and they also built a one-room structure.
For who was the house? Who's the structure for?
For their brother named Charlie.
Yeah, Charlie, the brother, exactly. Thank you so much. Okay, so they used this land in 2 different ways. First, the Lutzes would cross the land to get to the main road. And second, they built a house, they built a garden, they raised agriculture, they raised, there's some animals, there's some vegetables. They used the land different ways, okay? And they did this, Hannah, for how long? How long were they doing these activities for?
Probably like around 30 years.
Yeah, decades, right? Like a long time, okay? A long time. Okay. Is that Kyle? Kyle, so let me ask you a question, right? If you were the lawyer for the Lutzes, and you knew that they were walking across this land and building a farm on it and building agriculture stuff for 3 decades, what would you have advised them to do? What would the competent legal advice have been in this case?
Ask them for an easement, right, to use the property properly.
They need more than an easement. What did they acquire by using the land for 30 years?
Well,
One at a time, one at a time.
the land itself.
Adverse possession, right? The reason why this case is so frustrating and why it's in your casebook, I think, is because the lawyering was awful, right? Just as an aside, you will all be lawyers in about 2 years or so, right? Mm-hmm. God willing, right? You're taking professional responsibility now or later? Let me tell you a piece of advice. If you litigate a case like this, you'll be charged with malpractice. You will be sued for malpractice, right? I don't think you'll lose your own license, but you'll get in trouble. The lawyers here screwed up in a very big way, and let me explain to you why. There are 2 separate issues here, right? The first is adverse possession. Did building the chicken coop and the house and everything else give them adverse possession? Yes. This entire lot 19 through 22 was theirs. They owned it. They acquired it through adverse possession, done. Okay? But the lawyer only gave them a more narrow option. Andrew, what was the narrow option that the lawyer thought they had? It wasn't adverse possession, it was something else. It begins with a P. One at a time, please. Yeah, just wait. If you notice, I'm not asking people to raise their hands. I won't do that. So just when I call on you, that's your time. If you want to raise your hand for a question, you can do that. All right. So Andrew, what did the lawyer for the Lutzes actually recommend they do? There's a word for it. See those beautiful green and pink highlights in your book. Important words. You have adverse possession, and you have this other word. I'll come back to Andrew. Anyone else? Yeah. Prescription. Thank you, Natalia. What is prescription? It's not like when you go to the pharmacy, you get medicine. That's not what it is. What's prescription? A right to do what? How are they accessing the land? Just be a little more precise. You're almost there. Not to use it to do what? How are they using the land, Natalia? What were the Lutzes doing?
Oh, they were farming?
No. The farming is adverse possession. Yeah.
They traversed or traveled.
To walk across it, right? Prescription is kind of like adverse possession. It's related. It's like a cousin, right? With adverse possession, you get the entire lot. With adverse possession, you get the entire lot. But with prescription, you only get the right to walk across it, or the right to use it in a certain way. Remember the bundle of sticks from property? Remember that image, right? With adverse possession, you get the entire bundle. With prescription, you get one stick. In this case, the right to walk across it. You can have different types of prescription. You have the right to swim, the right to hunt, the right to maybe climb on a mountain, whatever it happens to be, right? Prescription is more narrow. Prescription allows them to walk across the land. So the lawyer in this case wasn't thinking right. He only argued that this 30-year history gave them the right to walk across it. And he conceded in court that the Lutzes did not own the property. Big mistake. Let me tell you something. You will all be lawyers, God willing, right? If you make an argument in court on behalf of your client's stuck with that position, right? Remember the concept of estoppel, right? You're stuck with that position. So as a result of the first lawyer's mess up, the clients were then stuck with the argument that they didn't own it. But that's wrong also, right? Because if they acquired it through adverse possession, it's theirs. You cannot give up property with words. Why? The statute of frauds. You can't convey property without a writing. Even if the lawyer says in court it's not ours, that's not enough. You can't orally disclaim property. Okay. I want to get that out of the way before we get to the von Valkenburgs. That's a crazy story also, right? Those guys, they're just as nuts, these neighbors, right? But the lawyering in this case was just bad. And there are other screw-ups we'll get to in a few minutes. Okay, so let's come back to you, Andrew. Describe for me the conflict that arose between the von Valkenburgs and the Lutzes.
The von Valkenburgs bought land west of Gibson Place, and they built a home there.
Okay, so so the von Valkenburgs bought a lot. Okay, then what happened?
Miss Lutz was annoyed by the children that were
Yeah.
in her
Yeah. And then what happened? What happened to the von Valkenburg children?
They got chased off the land.
Chased off with a what?
By Mr. Lutz with an iron pipe, screaming, "I will kill you."
Yeah. These guys were insane. I mean, I can't imagine these neighbors, right? I don't know what my neighbors' names are, but these people are like really threatening to kill They're the children of their neighbors, but my God, right? Okay, so then what happens? Keep going, Andrew, it's fun.
Mr. Lutz was arrested.
Yeah, he was, yeah. And this keeps going for a while. What happens next? Keep going.
Then the Valkenburgs actually bought lot 19.
Okay, now here comes the important point, right? The Valkenburgs purchased lots 19 through 22. Now, Tony, let me ask you a question. Who did they purchase lots 19 through 22 from? Who did they buy it from? How did they buy it? Who did they buy it from? Was there a seller? Did they buy it from the Lutzes? Where did they get it from?
The city of Yonkers near foreclosure.
They bought it from the government. How did the government come to own that property?
The prior owner defaulted on payments.
We don't exactly know, but at some point, decades earlier, the prior owner left, didn't pay his bills, whatever. We don't know, right? So generally, if property is abandoned, right, the government can hold a sale, right? And the purpose of that sale is to pay off taxes and such, right? So, Tony, the Van Valkenburgs bought the lots 19 through 22 at a sale from the county, right? Did the county own the property at that point? Who owned the property at the time of that sale?
They argue that
Yeah.
Lutz.
Yeah. This is the important point, right? And I think the dissent makes this point quite well. The dissent's correct in this case. You'll hear me say this often. The reason why these books are in your case is not because they're right, but because they illustrate a point. I think here the dissent had the better argument. By the time the Van Valkenburgs went to that foreclosure sale from the county, the Lutzes already owned the property, right? Their paperwork was worthless, right? They bought the lot from the government. The government didn't own the property to sell, right? You can't buy property from the government if the government doesn't have it. So the entire basis of the lawsuit was it was a fraud, right? Because they didn't have it to sell. I think the dissent is 100% correct on this point, 100% correct. All right, Grace, I think you're next. Okay, so, but the Van Valkenburgs bought this lot, and then what did they do next? They did something very spiteful.
Had it surveyed, the property.
Okay, they had surveyed. What next?
And then
They did something very spiteful.
they got their lawyer involved.
Yeah. Yeah, what else did they do?
Legal action.
Yeah, there's legal action. Okay, fence. Okay. They built a fence, right? They built a fence. It's called a spite fence, S-P-I-T-E, right? Basically to block traveling across it. And dogs, right? Dogs? They got threatening guard dogs. Think like Mr. Smithers, right? They got these threatening guard dogs to prevent the Van Valkenburg, the Lutzes from crossing over the land. So they did everything in their power to block it. Okay, now the litigation begins. Is that Morgan? So Morgan, let's just now repeat. What argument did the Lutz's first lawyers make, the county lawyers, right? What argument did the county lawyers make in court?
For the first one,
In the very outset, yeah.
that they own the land because they exercise control over it.
No, the Lutz's. What did the Lutz's lawyer argue at first?
That they had approved the land by building the structure.
What claim did the Lutz's attorneys make at the outset? You don't have to point. You can do it yourself. I have very good hearing, by the way, if you whisper. I can hear everything.
So they have the prescriptive right.
Okay, very good. Thank you, Morgan. Right. Initially, the lawyers for Lutz argued for prescription. They say, look, my clients walked across this land for 30 years. Therefore, they have the right to keep walking across it. Take down this fence. Elliot, what should they have argued, Elliot, instead of prescription? What should the lawyers have just argued at the outset?
That they owned it through adverse.
Bingo. 4 elements are met for adverse possession, right? For whatever reason, the lawyers for the Lutzes conceded. They admitted that the Van Valkenburgs owned the land. This was just a screw-up, right? The tax foreclosure sale was not valid. It was void. All right. They lost that case. I'm sorry. Well, they filed this case just for prescriptive easement, and then William Lutz died. And at that point, a new action was filed. And the new action actually argued that they owned the land entirely. And that's the case that we have today with majority opinion. So let's walk through each of the 4 elements as the majority construes them. Is that Grant? So Grant, there's no question that they entered, right? There's no question that it was continuous for like 30 years, right? Or is there? Now, there's no question they were there for 30 years. But does the majority find that they actually used the property for 30 years? This is part of the opinion that's wrong, but I want you to tell me what the majority says here.
They said they didn't.
Yeah, what's up with that? Walk me through the majority's reasoning, please.
They said that they didn't cultivate or improve the land.
Which part of the land?
That they were going through with the path, and that the house that they had built was a small shed or shack.
Mm-hmm. What does the majority actually require to meet the continuity requirement? It's kind of weird. Look, they built a chicken coop here, they had some vegetables there, the house there. What does the majority actually demand?
A defined boundary.
But I mean, if you take the majority seriously, what would they've had to do? Let's just say it's an acre, right? How much of the land would they have to use to meet the continuity requirement?
I guess the whole acre.
Bingo. Everything. Right. If we read the majority seriously, right? If we read the majority seriously, I'm sorry, this is element 3. I skipped number 2. If we read the majority seriously, the continuity requirement requires using the entire thing, right? Which is insane, right? It's not reasonable to demand that someone use every square inch of a piece of property. They had their chicken coop, they had their vegetable garden, they had the little house for Charlie. You know, they use the land, right? So under any, I think, reasonable reading of the New York law, the Lutzes met the continuity requirement. All right, so I think that's the first mistake the majority opinion made by Justice or Judge Dye. By the way, in New York, the highest court is called the New York Court of Appeals. In New York, the Supreme Court is actually the trial court. Why? Because the Supreme Court has general jurisdiction. They can hear any case, right? And the Court of Appeals is the highest court. Maryland's the same, the Maryland Court of Appeals. Now you know. That's why if you ever watch Law and Order, it's always Supreme Court, right? But it's actually the trial court. So the third element, I think the majority botches. But let's talk about the fourth element, right? Now, Zach, if you were to ask Mr. and Mrs. Lutz, you know, what were you thinking for those 30 years? What would they probably told you?
That we own the land.
Yeah. Yeah. They say, look, it's ours. Like we're acquiring it, right? It's ours. What standards, Zach, does the majority require Mr. and Mrs. Lutz to have? It's kind of weird. I want to make sure everyone understands this point.
To declare their right hostily to the owner.
Yeah. Basically, they have to know that they. I'm going to get the actual language because it's a very weird one, right? Okay. Where is it? I want to get the actual analysis. Okay. According to the majority, right, Lutz would have to concede that someone else has it. Right? Lutz would have to acknowledge that it's not his. This cannot be right. Right? No one could ever adversely possess land if you acknowledge that someone else has it. The entire purpose of adverse possession is to say, it's mine. Right? You're asserting a claim of right. This is my property. And there are different ways of doing this. But the majority basically says, you have to acknowledge that it's not yours. But if you acknowledge it's not yours, guess what? you don't meet the fourth element of adverse possession. Right? You always, to satisfy the fourth element, you have to have some claim, yep, this is mine. But the majority basically says you have to acknowledge it's not yours. And that's wrong. And I think the dissent makes his point very well. Right? You don't need to acknowledge that someone else has it. Right? That the Lutzes had the correct state of mind. They said, yep, this is ours. And that should be enough for adverse possession. All right? Questions? All right, so the four elements, right? 1 and 2 are fine. He entered. They were living there openly, notoriously. That's fine. But it's the third element that is funky, right? Where they require to use 100% of the land, which is wrong. And the fourth element is contradictory. It requires a person to acknowledge that they don't own the land, but doing so defeats the claim to adverse possession. So this is a case where the majority is it's a very strange rule. And I think what the dissent is hinting at, it doesn't say it, but I think what the dissent's hinting at is that the majority doesn't like adverse possession. They think it's unfair. And they make it virtually impossible to accomplish. Right? Because after this decision, you can't get adverse possession. You're not going to do it. It's impossible. So the majority reads the adverse possession statute so strictly that it becomes impossible to establish such a claim. Okay. Ah, well, the notes after the case talk about it, doesn't it? See, you got to read the notes, my friend. In this book, you need to read the notes. The notes explain at some length what happened after this case. See, I'll be flipping nervously. If you don't read the notes, you're not prepared for class. You're going to just miss stuff. So make sure you read the notes. So I will summarize it today, but for the future, you need to read the notes. This decision proved to be very controversial, right? Later, the New York Court of Appeals basically overruled this case. And they said basically, even if you know the land belongs to someone else, you can still satisfy the fourth element. You can still have a claim of right. Right? So this is no longer good law. And indeed, if you want to read the notes, it tells this crazy story of how this litigation went on for years. And in the end, the Lutzes kept the land. They prevailed after everything, after years of litigation. What a disaster. Okay. Questions on von Valkenburgh versus Lutz? Yeah, Tyler.
Sure. Where was the party that was supposed to be paying the property taxes?
I don't think it's in the facts. And if you think about it, the land wasn't occupied for 3 decades, right? A person could have died, could have moved. We just don't know. Property is a weird thing where you can't really abandon it, right? You can't just walk away from it. Someone always has to own property. There's always an owner somewhere. The government has to send a bill to someone. And if that person disappears, the government basically puts it for sale so someone else can pick it up. But the law doesn't allow property to just sit there unknown. Someone has to be the owner, at least of record. And maybe the government just lost track of who that person was. Again, in the 1912s, 19-teens, I don't even know what property taxes were like. Maybe it was just something that wasn't done and the city didn't care. They may not even know. Maybe just been lost to the sands of time. Oops. I will trip and fall at some point this semester, so just don't laugh too hard. These are very dangerous classrooms, though. The way they have, because see, it curves, right? So it's like walking here and then it drops down. It's a terrible design. Okay. All right. Questions on von Valkenburgh versus Lutz? All right. Let's go back to our fourth element. Right? Adverse and under claim of right. There are different standards. There are different standards in different jurisdictions that define this fourth element. And is that Mackenzie? All right, so Mackenzie, there are three different approaches to this fourth element, and I know this becomes confusing, right? Three elements for the fourth element, right? Let's talk about, Mackenzie, the objective standard, right? What's the objective standard for adverse possession?
I don't remember where that is.
It's in the notes.
I know.
You have to read the notes. This is not negotiable.
To be completely frank, I actually just don't remember what it was.
It's there. I'm sorry? What is the objective standard? Matt?
So I didn't have it written down as objective. I just have three different states of mind.
Okay.
Down the notes. One, state of mind is irrelevant. Two,
Oh, no. Just one at a time. What's the objective standard?
that the state of mind is irrelevant.
Okay, thank you. We'll start one at a time. Okay. The first standard, and again, I can't implore you enough. I know the notes are long and tedious, and there are lots of boring citations to articles you'll never read. Unfortunately, you have to plow through them. This book is bad, but it's the best one. There are lots of bad books. This is just a okay book, and I frequently email with the author, Syllabus, the last guy, and I complain about stuff, but it's the best one, even though it's not very good. What I don't like about this book is the notes are very long and tedious, and they include links to lots of articles which you're never going to read or care about, I know, but unfortunately you need to read them. In particular, there are problems and questions. Answering those problems on your own is very important. We'll do one in a few minutes, right? But you need to be able to answer these questions because they're basically previews of the exam. Right? Do those questions, please. All right. So Matt, one more time, describe the objective standard.
The state of mind is irrelevant.
Okay. Okay. This is basically the standard in the UK, in England, right? It doesn't matter what your state of mind is, right? If you go on a piece of property and you claim it's yours, you're done, right? You don't have to have any hostility. You don't have to make any claims. You said, look, this land's mine. It doesn't matter whether you're mistaken. It doesn't matter whether you're hostile. Okay? This is the easiest standard to apply. With this one, all it's required is you walk on the land and say, it's mine. Your mens rea, your intent is irrelevant. All right, is that Ethan? What's the good faith standard?
I thought I owned it.
I'm sorry?
I thought I owned it.
Yeah, thank you. Very good, right? It's you walk on a piece of land and you said, you know what? I thought I owned it. Think of Danny's parents from a few minutes ago, right? You're like, look, I lived here for 20 years. I got this deed. I bought it. I paid a mortgage. I thought it was mine. You were wrong. Whoops, my bad, right? You made a mistake. The good faith standard is you're saying, in good faith, I claimed it was mine. I was wrong, but I thought it was mine. Okay? The more modern trend is to have this sort of good faith standard. And we'll do a couple cases like this, right? Now, the third standard, is that Morgan?
Yeah.
Okay, what's the third standard, Morgan? Who? Yeah, okay, perfect. Yeah, Mr. Robinson, right? Mr. Robinson is like the perfect example of aggressive trespasser. Like, it's not mine, it's going to be mine, get lost, no trespassing, right? He has hostile intent. And it's not even a jerk, right? It wasn't that like, he was being mean. He had to make a fuss about this in order to have the requisite state of mind. Again, he knew what he was doing, right? He wasn't like, he wasn't just making stuff up. He actually did his homework on this. So in Texas, you have what's called the aggressive trespasser standard, where you must intend to take it, even if you know it's not yours. Say, it's mine, I want it to be mine, too bad. If number 2 is called the good faith standard, you might call number 3 the bad faith standard. Although I don't like that test, but you might want to use it to contrast them, right? I think bad faith is a bad word. I don't think Robinson was asking bad faith. I think he was using the law as it exists. Okay? But we have this sort of bad faith standard, if you want to use that phrase. Again, Texas is a harsh doctrine, right? It's a aggressive trespasser jurisdiction. Okay. Is there any questions on that? Let's take a look at some questions. If you go in your book on page 88, please. Again, you should be able to see this in your book and or on the screen. Is that Ashley? You want to read for me, please, problem number 1? It's on the bottom of 88. It's on the screen also.
O owns and has been in possession of a 100-acre farm since 1975. In 1994, A entered that 40 acres under color of an invalid deed from B, who had been claimed for land in the entire 100 acres. Since the entry, A has occupied and improved the back 40 in the usual manner for the period required by the statute of limitations. A brings suit to evict O from the farm, claiming title by constructive adverse possession.
Good.
What result?
Okay, so let's walk through this one step at a time, Ashley. You have a 100-acre farm. A squats, I want to use that word, squats in the back 40 acres with an invalid deed. What do you call an invalid deed? What do we refer to that as? What's that phrase we use? Bingo. Okay. So A has color of title. And indeed, this is an example of a, is that Bina? What would the intent be of a person who has a fraudulent deed? What intent would they usually have? How would we describe their intent? What are the 3 types of intent we have?
Hostile. We have the objective standard, which is the irrelevant state of mind, and we have the good faith, and then the aggressive trespass.
Okay, so if you have an invalid deed, what do you think your intent is? What state of mind do you have? What's your claim?
Well, I'm gonna
If a person has an invalid deed, where'd they get it from? How do you usually get an invalid deed? What do you usually do to get one? Yeah, and what did the crook do to you? Did you would someone willingly buy a property from a crook? What usually happens in such a case? You were cheated, right? You thought it was yours. So which standard do we have here? Bingo, bingo. Everyone heard what you said, right? If a crook swindles you, if you get cheated, you get this invalid deed, you're probably going to have the good faith standard, right? You thought it was yours, okay? You thought it was yours, but it wasn't. Okay, so we have color of title, we have the good faith standard is satisfied, but Caleb, the person's only using 40 acres out of 100 acres. And they've improved the back 40 acres. Can A claim adverse possession for the entirety of the lot, all 100 acres? What do you think?
I guess it depends on which part they thought they owned.
Well, which part were they cultivating?
Just the 40 acres.
So what can they claim by adverse possession?
Just the 40 acres.
Okay, very good. 1 second. Right? Here, A is suing to evict, I'm sorry, A brings suit to evict O from the farm. Right? Again, the squatter is trying to sue the original owner. Now, the owner has his claim to the first 60. The squatter has the claim to the back 40. Effectively, the lot was split in half, right? So the original owner still has his original 60, but the original owner lost his claim to the back 40. Make sense?
With the invalid deed, was it only for the 40 acres or the total 100 acres?
You know, the question doesn't specify.
Because in my head, if they had color of title the 100, then wouldn't they?
You know, I don't think it would matter. Okay, so let me make sure everyone understands your question, right? The question's framed, I think, in a little bit of a vague way. It just says invalid deed. It doesn't say if the deed is for 40 or for 100, right? Let's say the deed said only for 40. I think that weakens the claim for the entirety of the property. But, and here's the big but, you still have to satisfy the continuity requirement. And to meet continuity, you have to actually cultivate all 100 acres, and they didn't. So no matter what, I don't think it matters, but I think here the deed wasn't precisely defined. It's a good question. Yeah, is that John in the back?
Yes, it actually does say the deed for the entire 100 acres.
Did I misread that? Where's that?
Oh, after the pair.
Oh, okay. Okay. Well, there you go. But I don't think it really matters one way or the other. Okay. Yeah, but is the 100 acres about entering or the deed? Oh, I see. Yeah. Oh, it's written in, I think, in an ambiguous way. One of my grievances is legal writing's awful. It's terrible. I don't think you'll have me for. Have you taken con law yet or taking it next semester? Took it right. Well, I'm an editor of a con law casebook, and I basically rewrote the entire book because I think most legal writing's awful, and like it just pains me to read other casebooks I didn't write. So it's just it's painful. But just like that parenthetical's in the wrong place, right? Right? Isn't it? It just where the parenthesis actually makes the sentence ambiguous. Yeah, is that Andrea?
I was wondering about the exclusivity.
Yeah.
Of it.
Okay, go ahead.
So, your first element, you have to have exclusive, like you're not, I guess is it just like just not being invited on, or is it a matter of?
Are you talking about entry, the first element? I'm not sure what you're asking about.
Yeah, well, you have entry and it has to be actual and exclusive. So.
Are you asking about if multiple people can squat? Is that what you're getting at?
Well, I mean, you have the owner who, I guess, you don't know what's going on with them in the front six. You just know about what's going on in the 40.
Right.
So.
I'm not sure I understand your question. I'm sorry.
Okay.
One more time.
I mean, the way I answered it is A will not be able to evict O because while A's use of the back 40, they're using the back 40.
Mm-hmm.
It's not shown that it was exclusive, that they didn't have this other entity on the land.
Who's they?
So that A is not showing that O was not already on the land, that they're not exclusive.
Well, we know for sure that O was not in the back 40. We know that for sure. Why do we care about the other part? Oh, you're saying that are you saying that there might be another squatter who took over the 60? Is that what you're getting?
I'm saying O might be on the 60, but they're looking at the 100 acres.
Right. No, but the eviction was from the back 40.
Oh.
Okay. Very good. All right. Glad to clear that up. Yeah. Andrew.
So, right here it says actual possession under the color of title of only one part of the land covered by the defective writing is constructive possession of all the writing describes. So if the defective title
was only for Ford.
Was for the full 100.
Yeah.
Then her being on the 40 would be sufficient
for claim of right. Yeah.
For claim of right.
But not for the continuity requirement.
I thought we discussed that under the continuity requirement.
Yeah.
You don't have to possess the whole entire.
Well, I think now see, I love these questions. They give debate. With continuity, right? Let's say you have a 40-acre lot and you use a little bit here, a little bit there, a little bit there. Here we have 60 acres that were untouched. I don't think it goes that far, right? I don't think even the dissent in the New York case would go quite that far.
Okay.
Make sense? All right, good questions. Yeah, see.
I had a question about the open and notorious element.
Yeah.
Is it considered reasonable if someone's on your back 40?
Yeah. I mean, it has to be based on the circumstances. If you have a 40-acre lot, people can be moving around a lot, and you have to be able to see them coming and going. Yeah, there's some note cases about like caves and some weird stuff, right? Right, where something's below surface, but you have to do it in a way to put the person on notice reasonably. Yeah.
Since we said that this person is acting in good faith,
I think they are. Yeah.
Would it not be reasonable for them to want to evict the person before, like if they see somebody on the front 60, if they see somebody else running?
Why did they wait this long?
Right. I mean, they should have evicted that person immediately.
Well, from the flip side is, they wouldn't have had any sort of adverse possession until this point. So think about it. If they had tried to go evict the person in the first 60 early on, they would have been shot in the face because they would have been kicked out altogether, right? In other words, let me explain Stephen's question. If A had tried to evict O early, before A acquired it through adverse possession, A would have just shot himself in the foot because he'd be kicked out. Because he would realize, wait, it's not mine. because he was operating under the assumption that with the fraudulent deed, he would probably recognize, oh crap, that's a bad deed, and he would have lost. So in this case, A was probably smart for not taking any action. Okay, let's do the last case, or the second case. Only 2 cases today. Usually there are more. This is I think a case everyone can kind of relate to, right? It's like an oh man, that just sucks kind of case. Is that Elizabeth? You're next. You want to give me the facts, please? In Manillo versus Gorski from the New Jersey Supreme Court. Yeah. How many inches? I'm sorry.
15.
Thank you.
And so the issue in dispute is whether or not that constituted adverse possession if
Yeah.
the possessor didn't know of
Yeah. So let's just forget about the court opinion because I think it's kind of weird. But let's just talk about it as a general matter, right? You have 2 neighbors. Some of you have houses. How many who have houses ever actually check the survey of where their property lines are? I'm guessing none of you. Right? Oh, you did.
Yeah, we had a guy that lived with like a little bit of wooded area that kind of separated the houses.
Yeah? So you need to check the survey?
Well, he'd come back behind our house. He was actually the one that prompted us to check the survey because we went back because we were clearing land to build a house.
Right.
And we went back far enough and he came yelling at us, oh, you're on my property, get off. And so after he kept doing that a few times, we checked the survey and we're like, nope, it's actually here where the pins are. Quick one over, quick one over here.
Someone else, I think?
We just did it because we had a pool put in, so we were like checking to make sure we weren't encroaching on the utility.
Oh, that's very kind of you. All right, so generally most people don't bother checking a survey. And in this case, you have a neighbor, who made some improvements to his home, and he built a new staircase. And the staircase went over the line by 15 inches. Right? Was there entry? Absolutely. Was it continuous for the number of years? Yes. Was there a claim of right? Oh God, Dakota, you need to make a bigger font. That's hard to read. Just double it up with marker later. Dakota, let me ask you this question, sir. What was the New Jersey doctrine? Which of the 3 standards did New Jersey previously adopt before this case? Which one did New Jersey adopt before this case?
Aggressive trespass.
Yeah, it's called the Maine doctrine, the Preble doctrine, right? Which basically says you gotta be like Mr. Robinson, right? You have to go, guns out. It's mine. It's mine. It's mine. I found the cap. Someone dropped the cap in my last class, and it's here. Okay, so wherever we'll make a match later. Okay, thank you. So Maine and New Jersey have previously used this aggressive trespasser standard. Now let me give you a preview. Any case you have from the New Jersey Supreme Court will reverse the common law rule, without fail. I promise you. If there's a case in this semester from the New Jersey courts, they're about to reverse the common law. That's what they do. They reverse the common law. Okay? So what does the court do here? They abandon the aggressive standard, and they adopt the good faith standard. Right? So here, we have a case of good faith mistake. They thought, oh, wow, I thought the staircase was on my lot. Okay, I'm wrong. That is enough to satisfy the good faith standard. So far, so good, right? In other words, the court says, we're going to change standards. Now, Alexis, right? Why does the court abandon the hostile standard? Why do they move to the good faith standard? They give a lot of reasons, but what's like their thinking?
They felt impelled by existing New Jersey case law.
More?
That holding is argued by the...
What are some of the policy reasons the court gives for abandoning the hostile trespasser standard? Do you have it? Courtney?
This so-called bad faith standard rewards people acting in bad faith, whereas the good faith standard protects those acting in good faith.
Yeah, it's kind of weird, right? The bad faith standard rewards like people like Mr. Robinson who are coming out and just trying to take advantage of the situation. But here you have neighbors who, in good faith, built their staircase. And they thought it was theirs, and they did it for a number of years. So the court says we want to reward those who act in good faith, not those who act in bad faith. Josh, please. What's another reason why the court abandoned the hostile aggressive standard?
Just gonna say that same reasoning.
What's like the F word, which I don't like very much, but you know, sort of describes the holding, right? What about it? It's fill in the blank. Not that F, another F word.
Fairness?
Yeah, this is about fairness, right? At bottom, they say this is an old rule. We're going to abandon it because it's not fair. And every New Jersey case basically says the same thing. Okay, but, and here comes the last bit, and I'll let you after this one. They do something different, right? Is that Javier? What does the court do to the second element? The notorious element. How do they sort of modify it? The open notorious requirement. Like, how do they sort of modify it? No presumption that what? Why can they not presume here that there was knowledge of the encroachment?
Because it's not like they actually look at the survey lines.
Okay, very good. So let's go back to our elements, right? Right, open and notorious. If you have a guy walking across your property, that's easy, open and notorious. But if you have a staircase that encroaches about 15 inches, about this much, right? Maybe this much, I can't count. It's not enough to put the owner on notice. And the court basically says that if something's so small, if an encroachment is so small that requires a survey to fix it, it may not satisfy the notorious requirement, right? You cannot presume, as you can't assume that the person's on notice if you have such a small encroachment. So what the court does is send it back down to the lower court and say, did the owner actually know there was encroachment? Of course not. He didn't know. If he did, there would have been a different case. Instead, here's what they do. They say, okay, sell it, right? Force the owner to sell the land on which the staircase rests and set a price. That way, everything stays the same, right? Everyone's happy. You leave the staircase where it is, you get some money for trespassing, and you go home. And in the end, they paid $250 for the little, sliver of land. You saved a trip to the Supreme Court by just buying it. Again, the New Jersey Supreme Court just makes stuff up. This is what they decided. It seems fair, I don't know, but they just made it up. Any questions? All right, I'll see you all Thursday. Thank you so much. And I'll be in my office at 3:30 if you want to come by. I'll be there today after your next class.